to everyone. This is a webinar about the patent box and the changes that are taking place in the patent box imminently. We are expecting a smooth run through for the next hour. It'll be myself speaking and then two members of the Treasury team whose bios you should have seen before this webinar started. We are not expecting any fire alarms or other forms of interruption, but we are sitting in 55 Baker Street here in BDO's offices, so we can't completely predict that. If something awry does happen, we'll let you know and we'll pause things. I will speak very briefly about the patent box rules as they currently stand, and then the members of the Treasury will speak about the changes. We'd like questions to be we'd like questions to be asked throughout, and so please do fill in the question box and ask as many as you can during the entire presentation. We will generally leave answering them to the end to keep the webinar flowing, but please don't let that stop you from asking them. Okay, so just to get started, we still need to know, of course, what almost seem to be the old rules now. You know, they're 3 years old, so we can call them the old rules. They remain relevant. They are now subject to effectively a new bolt-on criteria, which is very much, at least to my mind, being thrust upon us by developments in international tax law. What I've found out in the marketplace is there's been a level of client resistance to investigate the patent box and how they can use it whilst these international challenges have been continuing. So we are, of course, duly expecting a nice flood of patenting discussions and patent box discussions to come through in 2016. I've got quite a big slide deck here to cover. Please know that because you're really here to listen to the Treasury speak, that I'm not going to cover all of it. I'll just set the scene by talking through where the patent box was before these changes. So, of course, it's been with us now for about 2.5 years. The ambition is to tax those profits attributable to qualifying IP rights at a corporation tax rate of 10%, rather than, well, what was, of course, 23% when it first came in, and will now be going down to 18%. And, of course, that 10% rate was phased in over a 5-year period. The standard calculation is that we look at our profits, which are potentially eligible for relief for taxing at 10%. We deduct two elements. The firstly is the sort of routine return, and secondly is the marketing asset return, so the return based on marketing spend rather than the IP. And then we get to an amount which would be seen to be the super profits, which are purely derived from the patented IP. Where we've got to really is that securing this tax incentive has provided a new reason to consider whether to register a qualifying IP right, and really to look and see whether there is a qualifying IP right. And there's been a lot of education going on throughout the tax and also the wider legal and patenting industry to help companies understand what they've got and what they can do with it. And I think that is starting to give rise to quite a significant change to how many companies manage their rights. There, of course, quoted companies being interested on the tax rate influence, and maybe private equity held or privately held organisations really focusing on what the cash tax savings can be. A lot of finance directors have wanted to know really what the likely tax benefit is before committing substantial resources, and to try and plug that gap in the market, we've invented what we call the realizer. It's a question of tax advisors trying to be innovative. We've put a great big capital Z in the middle of the word, as you can see there on that slide. We have created what is basically a spreadsheet-based calculator, which really is just there to help people understand what the potential might be for them to take advantage of the patent box rules and whether they should be spending their time and resources on it. We are flexing reflecting that spreadsheet to see what the impact of doing certain sorts of planning can be, and of course we're also flexing that spreadsheet now to take advantage to effectively reflect the new changes for Nexus. I'm going to move on quite quickly from the through the next slides, let people read them in their own time. There is quite a lot of work to be done within business to identify relevant IP income for any method of calculating relevant profits for patent box purposes. There's quite a lot of work to be done to help to identify how IP and patents flow into products or services and then flow into income and profits. And I think there's an amount of assurance work which needs to be done either within the business or working with advisors just to understand how that flow can work. Because as we said in the slide, we're certainly aware of some pharma companies and some single product companies that have systems that just naturally tracked income from IP rights, but that is by no means commonplace. So I think in terms of creating relevant IP income going forward, there is also a point there to think about, because to the extent that businesses are developing products and processes and services, and they currently use patents that have expired, for example, or they just use trademarks, there is really a piece of work to be done there to consider the IP and the patent portfolio and see to what extent patenting will be a good idea, not just for the tax benefits, but just more widely. And of course, in that context, we should not forget that there is a very generous part of these rules which enable profits earned in the up to 6 years before patents are granted to obtain patent box relief in the year in which the patent is granted. So I won't really dwell on these at all, but in terms of marketing asset return and how to best handle that, and also the sort of normalised return, it is quite important to think about transfer pricing and the extent to which you can use transfer pricing techniques to ensure that you're not deducting too much out of your patent box. That really divides into streaming techniques, structuring techniques, looking at the marketing return, and also looking at value chain, which are very standard areas of tax discussions that are going on to ensure that profits within the patent box are as high as they can be. And just a few points there on that slide around the sorts of things which we think are important when going through the process, through planning, quantification, engaging with the revenue. I think it's very important to engage with the revenue when embarking on any new form of tax incentive, whether it be R&D or patent box. Just to be comfortable that before you spend an awful lot of time and before you file a position, that you've discussed it where possible with the revenue, you've got them comfortable with the work you've done and the approach you've taken, so that when the return's filed, it should go through without too much complication. And the final box there, of course, there's low risk rating, and of course that is the ideal and the comfortable position for a lot of businesses to be in. So hopefully that's a very brief run through, a good run through and a good starting position from which to talk about the changes that are coming into patent box quite shortly.
Okay, thank you very much for that, Tony. It's Jerome speaking here. I won't introduce myself. I think that was done at the start with the slides. So let's get straight into it. We've got a summary slide up at the front, and I suppose I was going to talk about some of the things that sort of Tony's already touched on, but it doesn't make sense to duplicate that. There are sort of three key things we always pull out at the start of these things to say sort of what the key features are of the patent box. One of which is to get your effective 10% tax rate. Also that it applies where IP is either significantly developed by the taxpayer or is actively managed by a taxpayer within the group where development of the IP asset has taken place. And the claimant taxpayer needs to either own the IP or have an exclusive license to it. And I put these three sort of things up front simply to add a bit of context, I suppose, to the changes that I will be running through at the start of this presentation, where I'll sort of cover off the background and context of the changes, and then also introduce the Nexus Fraction, which specifically looks to impact the second bullet point on that slide there, in terms of whether we are now moving towards the patent box applying when there has been development activity undertaken by taxpayer, rather than you being able to now apply for the benefit of the patent box through the active management condition. So I'll talk a bit about that. Matthew will then fill in a lot of the detail around sort of what actually goes into the fraction to determine what benefits you'll be able to get from the patent box, and I'll sort of wrap up at the end with some key to-dos. And so just on background initially, the Nexus approach sort of came out of the BEPS project more widely, which is a 15-point action plan which was tackling base erosion and profit shifting by multinational enterprises, which was coordinated at the OECD. I think it's worth noting the sort of work on preferential IP regimes, which was undertaken by the OECD as part of BEPS Action 5, wasn't only in isolation done by the OECD. There was also some work done within the EU as well, which covered this, although the mantle was really taken on by the OECD to flesh out the rules. And the key point that the BEPS project has been looking at in the context of preferential IP regimes, such as the patent box, is how to safeguard them from profit shifting. And the solution to that has been to focus on the substantial activities criteria, where for a claimant to gain the benefits of an IP regime, it's been determined that the claimant needs to have undertaken the development expenditure, which leads to the creation of the IP asset, on which then the income from that IP asset falls into the preferential IP regime. So in the context of the UK patent box, what is known as the Nexus approach, which covers this, essentially says for you to access the benefits of the UK patent box with a 10% rate, the taxpayer will need to have undertaken the development of the IP asset, of which the income generated then falls within that regime. And there are details of this which are set out in the Chapter 4 of the 2015 report on Action 5, which was written by the Forum on Harmful Tax Practices. There you go. So let's dig a bit deeper into the fraction itself. And the Nexus Fraction is used to, as I said before, look at the substantial activities that are being undertaken by a taxpayer to inform whether or not it will be able to access a preferential IP regime. And it's essentially used as a mechanism to determine the proportion of profit which qualifies for a lower tax rate. So in the UK, that would be 10%. And we set out in this slide the fraction itself, which has a number of levers which Matthew will talk through in some detail after this. But essentially, it looks to apply a fraction which looks at one, the R&D activity which has been undertaken by the claimant taxpayer versus R&D activity which hasn't been undertaken by that taxpayer. And so it looks at in this fraction. It brings together your own R&D activity. It brings together R&D that you have outsourced to a third party. And for want of a better word, let's say that is good expenditure for the purposes of a fraction. And then it also looks at acquisition costs, so where you've acquired a piece of IP, which you then do further development on, and maybe you patent that. And also expenditures on related party outsourcing, so anywhere that you've outsourced within a group. And that is bad expenditure compared to the good expenditure we talked about, which is undertaken by the taxpayer itself. That fraction is then applied to the overall income that's generated by the IP asset developed, and will then be applied to that to figure out how much income you can bring into the regime. Now, there is a bolt-on to that, which essentially gives you a 30% uplift on your qualifying expenditures to sort of soften the blow of the bad expenditure as a taxpayer you may have incurred on either acquisition cost or related party outsourcing. And I suppose that sort of sets out the sort of the technical details of what the Nexus Fraction is trying to achieve. And I suppose the key thing is sort of what is the actual sort of practical impact for taxpayers. And so this slide sort of runs through those. So if we take the first point, I think it's clear that if a taxpayer undertakes all of their research and development in-house and hasn't acquired an IP asset, and neither does it subcontract to related parties, then its eligible profit to the patent box shouldn't be affected, i.e. you've done all of the R&D yourself, so you'll have a Nexus Fraction of 1. And so if that's the position you are in today, it's the position you will be tomorrow in the Nexus, i.e. all of your income will fall into the patent box. Although the Nexus approach does require a little bit more granular detail in terms of identifying separate Nexus Fractions to be applied to each separately identifiable income stream, rather than to total income, which is the approach taken under the current patent box. So essentially, under the current patent box, you have a patent in a product, say, all of the income from that product, and the simple facts would then fall into the patent box. What you may have to do in future is where you can separately identify that, you say that product involves 2 patents, each of which you can identify an income stream from. You will then have to apply a separate Nexus Fraction to the income stream from each of those patents. So, for instance, on patent 1, you could have undertaken 50% of the R&D yourself, and so you'll have a fraction of 0.5, and so you'll only be able to take 50% of the income into the patent box, and the other one you could have 100%, and so 100% will fall through. And so some additional work may have to be undertaken to justify the continued claim that you have today. As the Nexus Fraction is calculated on an individual taxpayer basis, so you're looking at the activities of the claimant taxpayer itself in terms of the R&D that is done, rather than on a group basis, the impact on the amount of qualifying profits which can come into the patent box will be magnified where R&D and IP ownership are split between the groups, and they're not housed in the same company. To the extent you have a R&D outsourcing sort of R&D contract arrangement, and the IP holder doesn't undertake any R&D by itself, then that will mean that none of the IP profits which are generated by that asset will be able to fall within the patent box. And so where those sort of things take place, there is a real impact on the patent box claim. And so in those extreme cases, or to cover those extreme cases, there are sort of grandfathering provisions, which again Matthew will go through in greater detail, which have been provided to give taxpayers the time to organise their affairs such that the impact from the Nexus Fraction isn't as severe once they've been able to undertake that restructuring. And so we've got a couple of examples here, which I think people can probably take away and read at their leisure, but essentially sort of sets out where you've got an IP asset, you've got different parts of expenditure under different parts of the fraction. You then apply that in the way set out in this slide to give you your Nexus Fraction. And that may sort of add a bit more colour, I suppose, to the viewers of this presentation as to how it will actually operate in practice. The one thing I will also mention is that the Nexus Fraction, as it stands, it's been recognised that it won't necessarily be a perfect tool in all cases to be able to take into account the significant development activity that a company has undertaken in terms of driving the value of the IP asset which comes out of the back end. And so there can be some scenarios, one of which is sort of illustrated in the report by the OECD, where, say, you are undertaking development of an asset, you acquire in an asset which you then further develop, you later find out that that asset didn't really sort of add anything to your development process. You write that down in your accounts. If the Nexus Fraction wasn't adjusted in some way, it would mean that the acquisition cost, which is bad expenditure, wouldn't be adjusted, and so you would get a real hit on your Nexus Fraction, even when that acquisition cost doesn't actually contribute anything to the value of the sort of final results of the R&D development process. And so to sort of soften the blow of that, there is a provision called the Rebuttable Presumption, which is provided for in the report, which enables you to adjust the fraction or apply a different basis, which sort of is consistent still with the principles of Nexus in terms of looking at the value of your development expenditure as informing the amount of IP income that can fall within the regime. And so in the example I've just given, one of the easiest things to do would be to strip that acquisition cost out of the fraction, and so it no longer diluted the amount of income available for relief. But there are some conditions around that. So the taxpayer must apply the Nexus Fraction first and show that the resulting ratio, and this is excluding the 30% uplift, is at least 25%, such that only taxpayers that are undertaking a significant amount of development themselves can access this. And they must also demonstrate the sort of exceptional circumstances, such as I've just an illustration that I've just made of the write-down of an acquisition. They must demonstrate that there are exceptional circumstances that the Nexus Fraction doesn't give an adequate result. It must also be reviewed on an annual basis and to determine the continued presence of those exceptional circumstances. And finally, where the rebuttable presumption is used, you can't actually go and use the 30% uplift for the fraction as well. So you can't adjust your fraction and then apply the uplift on top of that. Again, there's a sort of a short example which goes through that, which people can take away and have a look at leisure. But let's get into the detail of the fraction itself and how it's composed. And for that, I'll hand over to Matthew.
Thank you very much. So it's Matthew speaking. As Jerome said, I'm going to go into a bit more of the detail of what actually goes into the fraction. So I'm going to try and make everything quite understandable, but if I do fail in this, please do send in questions. We are keeping a track of them. Let's start with qualifying expenditure. This is the top part of the Nexus Fraction. So, as was mentioned, this includes direct R&D spend and also unrelated party outsourcing. So it's all expenditures relating to the R&D that's undertaken by the actual taxpayer making the claim, and it has to be related to the creation of the relevant IP assets. So we're intending to use our definition for R&D tax credits for this purpose. So the non-qualifying expenditure, so this would be the bottom of the fraction. This is expenditure that would have been qualifying had the relevant taxpayer undertaken it. So this includes related party outsourcing and also acquisition costs. So it should be pointed out that these are all figures taken on a cumulative basis. So it's not you add up all the numbers for the year you're making the claim. It has to be the cumulative numbers from all the years leading up to that. So on qualifying income, this is what the fraction is multiplied by to get the income that's benefiting from the lower tax rates. What we have here are the principles that we've gotten from Chapter 4 of the FHTP report. So in that it says jurisdictions will define overall income consistent with their domestic laws and income after the application of transfer pricing principles. And it should be proportionate, so this is trying to identify the exact income that's attributable to the IP in the product. So that means things like marketing and manufacturing returns are stripped out. This is all achieved through transfer pricing principles. So as I said, all these numbers are tracked on a cumulative basis. So this requires tracking and tracing of the expenditures and incomes related to the IP assets. And in the creation of this approach and in negotiations, lots of stakeholders and businesses are pointing out that it would be very, very difficult, if not impossible, in some situations, to track and trace these numbers to individual IP assets. So we were looking for a more flexible approach to this, something that businesses could actually comply with. So what we've ended up with is we still have the requirement to track and trace, but it's in a slightly more flexible framework. So it can either be to individual IP assets or product families. So this means for companies with IP and products that interrelate quite a lot. So there are some companies that have products with hundreds of patents in them, and indeed some patents are included in hundreds of products. In these situations, you can find a slightly higher level to track to. This does come with the requirement to track to the lowest level possible. So if you can track to individual IP assets, that's what you're going to have to do. And you have to have some sort of basis for using the higher levels. So you have to be able to show that because of the circumstances of your business, tracking to lower levels would be impossible and require arbitrary judgments, and the product or product family approach is much more appropriate. This requirement lends itself more to the streaming method of identifying patent box profits rather than the proportional split. So it's currently proposed that this is the only method that will be available under the revised patent box rules. So we have another example here. So this is a company with two separate assets with two separate expenditure streams. So we can see the first asset is based on direct R&D costs, but also subcontracted costs and contract research. But the second asset is entirely owned costs. So in this situation, because it's possible to split out the expenditure and the resultant income, the business will have to track to the lowest possible level. So that would be individual IP assets. We also have an example here that's demonstrating both the cumulative requirements of tracking and tracing and also the 30% uplift. So we have 3 years of expenditure and income here. In the first year, there's 100 arbitrary units of direct R&D spend. And there's no other expenditures and also no profits. So the Nexus Fraction equals 1, but there is no profit. So there's no profit that can be given the lower tax rate. And because the fraction is 1, there's no, it's all qualifying expenditure, there's no 30% uplift. So the next year, there's another 50 of direct spend and also another 50 on acquisition. So we can see here that the top of the fraction becomes 150, so that's 100 of the first year, with the 50 of the second year, and the bottom of the fraction becomes that 150 plus the 50 of acquisition costs. So in this case, there is the 30% uplift, and because the fraction with the 30% still less than 1 gets used the entire 30%. There's also 1,000 of income, so we can see the exact amount of income that will be given the lower tax rate. So in the next year, there's another lot of spend and another lot of income. We can see in this situation we've still got the cumulative basis, but because if we include the entire 30% of the uplift, the fraction would equal more than 1, we're limited to only 14%. But the good news is that takes the fraction up to 1, so the full 3,000 in this case of income will be given the lower tax rate. There's also in the chapter a method for dealing with the fact that this information has not been recorded historically because there's been no commercial reason to do so. So in this method, we use the entire historic R&D expenditure of the taxpayer as a proxy for expenditures and individual assets. So you're looking at whatever information you can get and creating the best picture possible of what the Nexus Fraction should look like. So this is allowed as a transitional measure, so you can build up cumulative data and expenditures by assets or products, and this will apply by way of a 3- or 5-year rolling average. So it's currently not set in stone whether we're using the 3- or 5-year rolling average or whether it's going to be a slightly more flexible approach. This is something that's being brought out in the consultation documents. So at the end of this rolling average, taxpayers will need to transition to the full cumulative ratio. So this is simply allowing time to create the real Nexus Fraction. And there will also be anti-avoidance measures built into legislation that will prevent abuse of these provisions. So the chapter also deals with joint development arrangements, such as cost contribution arrangements. I'm not going to go into too much detail with these slides, but the key point here is that joint development arrangements are not meant to be disadvantaged by the Nexus approach. So by a strict application, it would be quite a clear disadvantage because the profits that would get the lower tax rate would only be relating to the small bit of expenditure incurred by the relevant taxpayer, but it's taking the actual CCA participants' contributions into account. So we have an example here. This is directly lifted from the chapter, and it is a bit too simple to be a real-life scenario. So this is one of the things that we're bringing out in the consultation. If anyone is a member or a participant, I should say, of a joint development arrangement such as a cost contribution arrangement, it would be very helpful to hear from you and hear real-life examples of how you think this should apply and how the current rules would apply in your scenario. So as Jerome mentioned, there's some grandfathering provisions provided by the chapter. So this is allowing for the fact that it would be quite unfair for there just to be one date where the old rules fall away and the new rules are put into place. So there's a 5-year period given where some assets will be able to be grandfathered. So this is from the 30th of June 2016 until the 30th of June 2021. So the date next year, the 30th of June 2016, this is when the current regime, so the current formation of the patent box, will be closed to new entrants. And after the 5-year period, so until 30th of June 2021, those currently in the regime will continue to benefit through the current formation. But after that date, the only way to claim through the patent box will be through the modified Nexus approach. The definition of new entrant is clarified in the chapter and includes both new taxpayers not previously benefiting and new IP assets owned by the taxpayers already benefiting from the regime. So taxpayers which have met all substantive requirements on or before the 30th of June 2016 and have been officially approved by the Tax Administration, if required at that point in time, can qualify for the grandfathering. So it should be pointed out that this will apply under normal time limits, so it doesn't have to be the fact that the application is the election is going in before 30th of June. It can be made in the normal time periods. And it should be also pointed out that pending patents are allowed as a basis for an election into the grandfathered regime. So it doesn't have to be a granted patent before the 30th of June 2016, but there does need to be an application. So in negotiations over this approach, there were some concerns about possible abuse of these grandfathering provisions. So a safeguard has been created that would bar IP assets acquired directly or indirectly after the 1st of January 2016 from gaining the full benefits of the grandfathered regimes. This is applying if they have been acquired from related parties from countries that do not have a preferential IP regime in place already. This, in essence, prevents taxpayers from transferring IP from countries without preferential IP regimes into one that does, with the view to gain benefits of the grandfathered regime. So it should be pointed out that this does not prevent IP from gaining the benefits of any regime compliant with the Nexus approach. So if an acquisition is made after the 1st of January 2016, it will be able to make an election through the modified Nexus compliant version of the patent box after that date, after the 30th of June, I should say. So at this point, I'm going to pass back to Jerome to go through a few to-do lists.
Thanks, Matthew. So I think it's probably worth spending a little bit of time on these slides, I suppose just because they go through sort of the practical things that maybe businesses, taxpayers want to be thinking about in terms of how they get their sort of affairs in order to get ready for applying Nexus from the 30th of June 16. And so the first sort of slide concentrates on tracking and tracing, which sort of Matthew's just talked through. And I suppose the key thing to point out, I'd probably take these bullets in a different order. So if we start with the second one first, I think one of the key things to point out is that regardless of whether you qualify for grandfathering, so I think as Matthew's just said, you would have, say, 5 years under the current regime if you meet the substantive requirements of the current patent box before the 30th of June 16. So whether you qualify for that and you've got 5 years grace, or you take advantage of the proposed transitional provisions in terms of getting yourself into Nexus based on the total R&D expenditure of your company, rather than looking at a sort of more granular Nexus approach where you're looking at either IP asset by IP asset or product by product, you're going to have to eventually transition to this cumulative tracking basis, where you will have to apply Nexus as is. And that will apply from the 1st of July 2016 onwards. So these transitional provisions and the grandfathering are really to give you some additional time in order to build up a Nexus history, rather than to suggest that once you come out of the back of those, all of a sudden you'll just start tracking and tracing your expenditure from then. And so one of the things that needs to be done is you need to, as a company, start thinking about how you will track and trace your expenditure from the 1st of July 16 onwards. And so there are some things around that we can unpack in terms of what you should be thinking about. One is sort of how will you be identifying expenditure inclusion in the Nexus fraction, i.e. do you expect to be going down to the level of individual IP asset, or do you think that based on the conditions that Matthew's spoken about, you'd be able to go to a higher level where you'd be looking at products or product families? How are you actually going to record that information? So obviously that needs to feed into your fraction. Your fraction will be the thing that will be applied to determine how much income that goes through. So there is a significant amount of, I suppose, stress on the quality of information that goes into that fraction, which needs to be considered. I suppose one of the other things to do before the 1st of July 2016 is to go through the process to understand what your Nexus fraction may well look like, because it's only from doing that sort of initial work you may well find that there is something that you didn't expect, potentially based on how your business is arranged, whether you need to start thinking about undertaking some kind of restructuring under the grandfathering provisions to get yourself in a better Nexus position, or alternatively you may find that the Nexus sort of fraction gives you a very odd result, one you weren't expecting, on the basis that the fraction doesn't take into account the vagaries of your business, and so you can then look at maybe thinking about the rebuttable presumption. And so the second one, this is two of three, I suppose it's sort of touching on the grandfathering again. And so I suppose it's key to make an assessment as to what set of rules your IP profit will fall into, i.e. whether they will continue under the old regime for the purpose of grandfathering, or they will go into the new regime. And I suppose in terms of assessing which one of those regimes you will fall into, it's very key to remember Matthew's sort of points that he's brought out beforehand, that grandfathering applies on a sort of asset-by-asset basis. So simply electing as a company into the current regime before the 30th of June 16 does not, will not be sufficient to have all of your profits included in the current regime until 2021, I think that should be. If, say, for example, at the point that you go into the grandfathered regime, you have two products with patents in which qualify under the current regime, and then subsequent to the 30th of June 16, say on the 1st of July 2016, you develop a new product which is underpinned by a new patent. Just making your election before the 30th of June will not mean that the new product and the new patent within that, which has been developed post 1st of July 16, will qualify for grandfathering. Instead, that will go into the new Nexus compliant regime. And I suppose one of the things as well is to consider and really sort of take account of the safeguard and the effect of that will have on which regime the IP will fall into. And so that needs to be considered. But it also needs to remember that the safeguard doesn't restrict availability of you being able to go into the patent box more generally. All it does is restrict your ability to take advantage of grandfathering. And so to the extent that you are caught, you will still be able to get patent box benefits under a Nexus compliant regime. And then I think Matthew's already touched on elections will follow the current rules, so it'll be based on sort of a election in your return, which you can do 2 years after the end of the accounting period, as long as you make sure that you've met the substantive criteria as of the 30th of June. I suppose the last one, and maybe more important to, I would say it's equally important to us and to you, would be to sort of get involved in the consultation that we've issued. So that went out on the 22nd of October, and essentially takes you through the background to sort of where we've got to on the patent box changes, what we expect to happen to the old regime to make it Nexus compliant. So I suppose going right back to the beginning when Tony was talking through the current rules, those aren't being scrapped. Essentially, Nexus will be attached onto the end of those rules and incorporated within them as an additional filter in terms of the amount of profits which can qualify. And there are lots of questions in that consultation document which seek views on how best to implement Nexus in the UK, and sort of asks for practical examples on things like whether rebuttable presumption may well apply, joint development arrangements such as cost contribution and things like that. and also sort of how transitional provisions may apply in the UK, which it'd be extremely useful to get your views on, which will then feed into the legislation that will finally be laying before to update the current regime. And so key dates for that, I suppose the consultation closes on the 4th of December, and I mean, given it's quite a tight timescale, unlike usual consultation documents, considering we've got to put the legislation in or we've got to get it ready before the 30th of June 2016 to ensure we have a seamless transition to the new. And so we would be greatly appreciative of early responses to enable those to be taken into account in the ongoing development of the Nexus compliant patent box. So I think with that, opening up for questions.
So thanks very much. I think we've got a real clear run-through of the proposals there, and I know that my co-presenters are really anxious to hear from all of you on the line and on your screens as to your views and what you think of this, so that they can really help them to factor the views into the final changes that are made. We've had some questions come through. Shall I read them out?
Yeah.
So first, let's take this one to start with. If you have a 31 December year end, which I guess will be most or many businesses out there, do you have to conduct a split year assessment? I guess that's as regards the 30th of June changeover.
So I suppose the clear answer to that, or the easy answer to that, is no. I think as we tried to pull out, I suppose your patent box claim will be made on whether you fall within the old regime or the new regime will be based on whether you meet criteria for the old regime as of the 30th of June. And so to the extent that you do meet that, all of your profits in your accounting period would fall into the grandfathered regime. You wouldn't have to undergo any split of your IP profits between what happened pre-30th of June 16 and post.
Next question is, are there still provisions to apply patent box relief where companies don't patent their technology because it's applied to military or secure applications? And I don't think anything's changed there, has it?
No, it hasn't. I mean, we'd welcome sort of comments from that through the consultation process, along with any other comments on maybe sort of considering around where the current regime or the bits which will be retained can be sort of flexed if necessary. But I mean, there are no proposals as yet to expand the class of assets which will benefit from the patent box.
Okay, good. So that there's another question which is regards grandfathering, and when talking about that, we're talking about taxpayers who met all substantive requirements of the regime on or before 30 June 16 and have been officially approved by the tax administration if required at that point in time, can apply for or qualify rather for grandfathering. And the question is around, well, what does approved by the tax administration? It's on slide 28. What does approved by the tax administration mean in that context?
And I mean, this is one of these things where I mean, arguably, this is a transposition from the OECD report, and essentially, I would suggest the OECD report has been written in a way which deals with IP regimes which tend to be administrated by way of ruling, which is not the UK way as we do it through self-assessment. It's nothing to worry about in terms of the fact that will impact on your ability to claim from a UK perspective. Under the UK, it will simply be based on your self-assessment tax return, so you won't need to get a specific ruling as of the 30th of June 2016.
Yeah, you need to go to the revenue before then and try and get some sort of pre-clearance. It's just form your own assessment as to whether you're in or out, and if you're in, then you can do that.
Yep.
Okay, good. So we have another one, which is if I'm patenting on a patent basis, then clearly a new patent after the 30th of June 16 will be in the new rules, But what if I'm tracking at a product family or product family level? Is there no more grandfathering here?
So I think I'll fill on this one. So this is actually a problem we are aware of, and it does seem to be that kind of a strict application of the rules as described would create an inconsistency here, where you're allowed to track by product level, but then because you add in a new pattern, you'd have to kind of strip out the expenditure and income to that, and suddenly you're tracking at a pattern level, which wouldn't be possible because you've already proved that it's not possible. So there are a few solutions we're currently considering. It's got something based on maybe tapering the benefits between the regimes, or perhaps looking at the core technology of the product and seeing if that remains unchanged. Currently, we don't have anything set in stone, but we can say that we are going to be working quite hard to avoid a situation where you have to track and trace to impossibly low levels. So that would be to individual IP assets for a company tracking to product or product families.
There was a point of clarification raised that costs from unrelated parties are eligible, but costs from related parties are not. I think that's that is clarified. That's correct. And then we had quite a specific question, which is we are a UK company and we purchased the rights to some patented products developed by the seller and former owner who was a non-UK, Might the cost of acquiring these rights and the profits we now derive from them qualify?
So, assuming the acquisition, the acquisition has already occurred, and so that would have been pre-Nexus. So I suppose we've talked in this presentation about what would happen when you acquire something within a Nexus compliant regime. It will, and that will sort of be bad expenditure. The acquisition cost, or the acquisition expenditure will be bad, and so it will dilute your fraction. But obviously, that only applies when you're in Nexus. To the extent that acquisitions have been undertaken prior to Nexus taking place, there is no proposal to go backwards from the 30th of June 16 to assess what transactions may have occurred in the past, what the history of the IP asset was in terms of development, to then apply a Nexus fraction based on that historic data, which is purely on the basis of sort of practicalities, essentially. At the time you were undertaking these transactions, you wouldn't have known that years later in the future you would have been required to dig these out of the archives and then build a Nexus fraction around them. And so the answer to that is no. The answer to that is yes, in terms of the income will qualify going forward. And that is essentially what even the transitional provisions which we've spoken about only apply from the 1st of July forwards to enable you to build your history, because otherwise at day one you would have nothing to put into your fraction. So there will be nothing going backwards from the 30th of June 16.
Yeah, I think that highlights quite an interesting issue there for businesses who may be considering that type of transaction, and that the 30th of June 16 might be quite an important date for them. And there may be a number of transactions which people are looking at 2016 now and thinking, what are we going to do in relation to IP? Then June 30th of June 2016 could be quite a big date, and stuff to think about that.
Agreed. I suppose the only thing to mention there would be the safeguard when we're talking about acquisitions. So I suppose we can say you've got until the 30th of June as your sort of drop dead date to start making sure all your acquisitions are done by then, but you've also got this overlay on top of that where if you acquire something in after the 1st of January 16, then you'll be precluded from accessing the grandfathering. I suppose once thing we didn't touch on when we were going through that is that, and maybe it's not brought out in the conduct either, is that the 1st of January date as a test, which I suppose applies to say that acquisitions from territories which also have IP regimes, let's say the Netherlands or Spain or whatever, are good. Whereas if you acquire an asset from Germany or Denmark or whatever, that's bad. It doesn't necessarily seem as if it's something that may well be EU law compliant, and so we need to sort of go through the details of how that provision will actually apply. I suppose the key thing, I suppose, to keep in mind, I suppose, is that you won't have to think about how that provision may well turn out if you've done everything before the 1st of January.
Another question on grandfathering. So this is talking about where the initial application for a patent has been made before 30th of June 16, and perhaps envisaging that patent's granted by 30th of June, say 2020, that grandfathering could apply there so that the catch-up would be in the old regime. And I think that's right, isn't it?
Yeah.
Yes. That would take place. Okay. Question: does R&D expenditure include the cost of securing patent protection?
I think the answer is no.
No. Yes.
Because it wouldn't be a class of cost which would be available for relief underneath R&D tax credits, and so I suppose that feeds into the more general thing where when we're talking about the R&D expenditure which is feeding into the fraction, we're trying to backload a lot of that off the current sort of R&D definitions that we've got in CTA 2010 in terms of sort of looking at something that taxpayers are already familiar with rather than building definitions from scratch. And so to the extent that anything qualifies underneath there, then that will be what goes into the fraction.
Yeah. Time for one more, which is asking about the rationale for looking solely on a company-by-company basis rather than looking on a consolidated tax group or group relief group or some other sort of aggregated approach in a particular territory where the questioner has said, and I might agree perhaps, that it seems unfair when work is being done in the same territory by group companies but just in different companies within that group.
Yeah, and I suppose I would, in terms of the context of what group regimes are meant to do, so in the UK, sort of transfer of losses or sort of gains or whatever, and in other regimes in terms of fiscal consolidation, I would take that point. I suppose the reason why it's done on a company-by-company basis, and I suppose is the reason why active management is no longer something which can apply, so that sort of falls away, is because of sort of EU law concerns. And so to the extent that you've got activity being undertaken activity undertaken within the UK solely, you can't understand that there would be any profit shifting which would occur, which Nexus is meant to tackle. But to the extent of trying to create a sort of jurisdictional Nexus approach that just looks at the UK, you would then potentially be discriminating from undertaking R&D expenditure, say in France or in the Netherlands, from bringing that cost into your Nexus fraction. So if you're allowing it for UK but you're not allowing it for outbound, there's an issue of EU law compliance that we haven't been able to find a way round, which is why it applies on a company-by-company basis.
Right. I think that comes to the end of the questions we're going to have time for. So I think on behalf of all 120 or so people who've been listening at some point to the webinar, thank you very much. We really appreciate it, and I know we'll all appreciate it if some of those who've been listening in can come back in relation to consultation and really get involved with their views. We certainly appreciate that. We will send out copies of the slide decks to everyone who has registered, and certainly welcome questions. You've got a fairly short amount of time to respond to the consultation. You've got 2 more weeks. It closes on the 4th of December. So without further ado, I think we'll call a halt to the proceedings today, and let everyone start writing up their responses. Thanks very much. Thank you, everyone, and